So what is the difference between buying a property as a married couple and simply cohabiting? A lot of people believe that when they move in together and live together for a while, for example up to 2 years, some people think that they are going to have the same rights as a married couple. More and more people nowadays are moving in together, having families together without getting married first, but the law has unfortunately just not changed rapidly enough to reflect that. Now, it is very unlikely that a couple that are living together are going to have rights over each other's property, even if they've been living together for a long period of time, and even if they go on to have a family together, and it's not sufficient to just simply put the property into joint names and hope that that's going to deal with it. Okay, so there are three main ways that a house could be owned by a couple that are living together. Although it's rarer nowadays, sometimes couples will decide to put the property into one of their sole names. For example, if one of them can get a better mortgage offer in their own name or for tax purposes. The other person might have a claim over a share in the property, but it would be uncertain. It can be very difficult to prove. Sometimes someone will move in with their partner who already owns a property and make an arrangement, for example, where they'll pay for things like food and bills and the partner will keep making mortgage payments, but that would not be evidence that they own a share in the property. What a lot of couples do tend to do is to put the property in their joint names but go for the default position, which means they own the property together as a whole, and then on the death of one of them, the property would automatically pass to the one who survives. It's not always ideal, especially where you're a new couple buying a property for the first time, or if you've got children from a previous relationship. The other thing to remember is if you do separate, more than likely you're going to end up having a 50-50 share in the property, regardless of the contributions you actually made. So the other alternative is to each own a specific share in the property, which can be especially useful if you've both contributed different amounts. The only thing to remember in that situation is that the property doesn't automatically pass to the survivor, which could leave them in a vulnerable position. So it is very important that you do remember to think about making a will. So it is very important to properly document your intention from the outset to prevent any uncertainty or disputes in the future, because an informal arrangement isn't going to be binding. So whether you're purchasing together or whether you're moving into your partner's property, the first thing to really think about is a trust deed, which does provide binding evidence as to the shares which the property is held in, and it can also cover further arrangements you've made in respect to the property, and it can be as simple or as detailed as you like, depending on your own individual circumstances. Now, a trust deed will usually only cover things relating to the actual property and not any personal arrangements which you might have made between you. So in that respect, you might want to also think about entering into a cohabitation agreement, which can include other outgoings, for example, food and bills. It can also cover childcare arrangements and future events such as a separation, having children, or if one of you decides to leave your job, for example, to look after the children that you've had. So of course nobody wants to think about the possibility of breaking up, but it is sensible to think about these things before you're actually going through a difficult separation. There are also other outside factors to consider. For example, what if your partner was to get into financial difficulties, lose capacity or pass away? If you've not detailed how the property is held, it might be that you're not going to have any protection against third parties, such as creditors or outside family members. It is also really important to make or update your will. For example, if you were to die, would you want your share to go to your partner? And if they were to die, are you actually going to have the right to continue to live in the property? And what if you've got children from a previous relationship and you want to protect their inheritance, but also making sure that your partner doesn't lose the right to live in their home? Now, these things can be dealt with in your will, but only if you've made it clear from the outset how the property is held. And the other thing is that it is very important to revisit all these areas every time that you have a major life event.